Your Excellencies, Honorable Justices, ladies and gentlemen, good evening and vanakkam. All protocols observed. Greetings from the Republic of Seychelles. I am very delighted that I am participating in this global conference. I especially thank Dr. V.R. Sampath and his wonderful team for having given me the privilege and opportunity to share some of my views with you on the administration of justice in judges' perspective. Forgive me if I am a bit outspoken. I am no longer a sitting judge. I believe now I have more freedom to express my views. At times, the views we judges form from our first impressions later proved to be wrong, reasoning found to be fallacious, opinions divided, judgments are often been reversed. The reality has turned to be different from the perception of reality. Our perceptions have often misled us. To be honest, many a time I have changed my views whilst on the bench after hearing the arguments from the other side. We judges, though deemed to be perfect, are also human and so fallible. Therefore, what all I speak now must be treated with reserve and open mind. Be that as it may, administration of justice is not a mechanical process. It cannot operate in vacuum. Good administration much depends upon the good administrators, I mean the judges. They are, in my view, largely responsible for the administration of justice. An effective and efficient administration essentially needs the active role and collective commitment of the judges. Judges with the highest degree of integrity, caliber, and courage to do what is right, just, and fair. To quote Justice Kirby of Australia, in a pluralist democratic society, judges are the essential equalizers. They serve no majority nor any minority. Their duty is the law and to justice. They do not bend their knees to governments, to particular religion, political ideology, creed, to money, to tabloid media, or screaming mob. In upholding law and justice, judges have a vital function in a vibrant, multiracial, multicultural, democratic countries such as India to make sure that diversity of every kind amongst its population is respected and the rights of all protected. In my humble view, judges have to be always conscious and cautious and constantly remind themselves of their judicial oath and unwavering commitment to justice, to constitution, to the rule of law, to democracy, to good governance, to social equality, and to a corruption-free society. They should ensure that judiciary is an independent, impartial, strong, effective, efficient branch of the state and ultimately accountable to its people on whose behalf they are administering justice. They should continue to play their role as watchdog of the Constitution, safeguarding the fundamental human rights and freedoms of the citizens. Incidentally, we all know that freedom is not free. You and I are free today because some people have paid the price at some point in time. Many have sacrificed their lives and freedoms in order to gain freedom for us. The judges, through their judgments, shall maintain that the fruits of such hard-earned freedom reach practically every segment of the community in the existing socio-economic order of inequality. In the administration of justice, we judges ought to keep the path to social justice clear of all obstructions to achieve equal economic, educational, and employment opportunities for all to grow, and without any discrimination. whether they are rich or poor, whether they agree with us or not, whatever be their racial, sexual, cultural, political, and religious orientations. It is always incumbent on the judges to ensure that right to justice is one's birthright. It is universal that no one shall be denied or deprived of his or rights without due process of law. From my long experience on the bench, I would like to humbly state that we judges, like all men and women, are inevitably conditioned by the experiences we have gained during our erstwhile life. On the fundamental qualifications, if I may say so, would be the judges' ability to constantly weigh and assess themselves while judging others. Judge not, you be not judged, for with what judgment you judge, you shall be judged. Any inborn or accumulated prejudice or bias on our part, if goes unchecked and unrecognized by us, may have enormous adverse effect on the entire judicial system and administration of justice. Therefore, constant self-awareness, reflection, and self-assessment are basic attributes required of judges for their calling and an effective administration of justice. The existing system of administration of justice, litigation process, and adjudication of disputes are obviously destined to undergo a major transformation in predictable future. This evolutionary process of transformation from conventional courtrooms to virtual courts and online judging may even become inevitable in order to meet the changing and challenging needs of our time and society. For instance, the emergence of the new untouchability, social distancing, isolation due to COVID pandemic, climate change, and gradual disintegration of human values and families, institutions are now leading us to embrace a new world order. The judicial institutions and the system of delivering justice also need to advance with the advancements taking place on daily basis in information technology and science. Having said that, I would like to conclude by restating what I had stated about 10 years ago in one of my dissenting judgment in Bihari versus the Republic of Seychelles, Seychelles Court of Appeal, criminal case number 28 of 2009. It seems pertinent to repeat herein the prelude of that dissenting judgment, which reads thus, quote, I will humbly begin by saying that being apex in the judicial hierarchy, we, the Court of Appeal, are final. We are final not because we are infallible. We are infallible because we are final. The privilege of finality accorded to our decisions is a barometer of the trust and confidence the people of Seychelles have placed on us as justices of appeal, hoping that we would meet their expectations in the administration of justice. Needless to say, they have conferred that privilege on us with an implied condition that we would secure the freedoms, rights, and liberties of all the people of Seychelles, not only of those who appear before us as appellants or respondents seeking remedies for their individual grievances. Justice is, after all, rooted in public confidence. If we want to enjoy that confidence and fight for it, we must be prepared to extend it equally to everyone, whether he or she be a prisoner or a law-abiding citizen going about his daily business. In deciding cases, obviously, judges should look at the big picture and face the reality. We cannot isolate ourselves from the fabric of contemporary society and live in a legal utopia, cut off from the rest of the world. We cannot and should not lock ourselves in our ivory tower and turn a blind eye to the emergence of certain crimes that threaten social morality and the very existence of our society. After all, a judge is but an agent of society who enforces the social will that manifests itself in the law. Yet, he remains very much a part of the society he serves as he sits on the judgment seat and passes judgment on his fellow citizens. However, the sensitivities of the community are largely invisible, voiceless, and unrepresented in our courtrooms, while vociferous lawyers argue their cases to protect only the interest of their clients. In striking a fine balance between the interest of the individual on the one hand and the larger interest of the community on the other, we should never miss the forest for the trees. The interest of the majority, the law-abiding citizens in this country, is in no way inferior to that of an individual. The rights and freedoms found on the glossy pages of the Constitution and the statute books are guaranteed not only to the small minority who have the opportunity to appear before us as litigants, but is guaranteed to every citizen, whether he be an outside or inside the clutches of the law. A court of law, be it appellate or a trial court, should steer the law towards the administration of justice rather than the administration of the letter of the law. In that process, its primary function, amongst others, is to adjudicate and give finality to the litigation. However, in my view, such finality cannot and should not be given mechanically by the court for the sake of a technical conclusion of the case or for statistics, disregarding the sensitivities of the community to which we judges are accountable. In each adjudication, the court ought to ensure that all disputes, including the latent ones pertaining to the cause or matter under adjudication, are, as far as possible, completely and effectively brought to a logical conclusion once and for all. The good sense of the court, I believe, should always foresee the long-term ramifications of its determination and adjudicate the cause so as to prevent and control the contingent delays that could possibly proliferate in future due to multiplicity of litigations on the same cause or matter. It is tried to say prevention of potential delays, judicial delays through judicial foresight is always better than cure. Therefore, our courts in Seychelles should, as any other court of such foresight and sense would do in any part of the world, adjudicate the disputes accordingly and prevent the chronic delays that have cancerously afflicted our justice delivery system. After all, the law is simply a means to an end, that is justice. If the means in a particular case fails to yield the desired result due to procrastination, as it has happened in the instant case because of repeated appeals, remittals, and retrials over a period of many years, we have to rethink, reinvent, reinterpret, and sharpen those means of procedural and substantive laws, that is, the tools of our trade, in order to eradicate judicial delays, as Lord Lane once called it, the enemy of justice. Hence, the court should never hesitate, where circumstances so dictate, to adopt measures that are just and expedient to prevent the procrastination and the resultant frustration in the due administration of justice. Now then, I would simply ask, which is to be preferred, the means or the end? Ladies and gentlemen, before I conclude, may I leave this question for your determination, particularly when you are in a dilemma due to an irreconcilable conflict between these two, namely the means and the end. In other words, law and justice. Which is to be preferred? Having said that, I now, due to time constraints, prefer to adjourn the case for continuation of hearing from the next presenter or speaker. Thank you for your kind indulgence. May God bless you all. Once again, thank you. Vanakkam.